Hi everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Should you name your child as a beneficiary? Well, is your child a minor? Is your child an adult, meaning age 18 or older? And if over 18, if he or she came into a large sum of money, would they manage it wisely or blow through it quickly? Does your child have special needs? There is a lot more to the question. If your child is a minor, then I do not recommend naming him or her as a beneficiary of any asset, whether it's life insurance or retirement accounts or any other type of asset. The reason is if you pass away and those assets are payable to a minor child as named on a beneficiary designation, then the assets are for the minor child, but the child cannot be in charge of the assets on their own until age 18. So, a court would have to step in and appoint someone to be in charge of those assets until the child reaches age 18, at which point he or she will receive the assets outright. If you name a minor child, outright as a beneficiary, you are leaving it up to chance that if something were to happen before that child reaches adulthood, then someone else, likely a parent, but it could be a stranger, would be in charge of the assets and making decisions about how to invest those funds and ultimately how to spend those funds on your child. But what about adult children? In North Carolina, upon turning age 18, you are considered an adult in the eyes of the law. Let's say you are a single parent or a surviving parent and you've named your 18-year-old teenager or maybe 21-year-old young adult child as the beneficiary of a $1 million life insurance policy. If something tragic happens and you pass away, that $1 million will be handed over to your young adult with no more oversight. An adult that age may not be mature to handle that amount of money, or maybe is mature but could fall into peer pressure and use the $1 million at their disposal. They might end up using it in ways you would have never wanted. Maybe you got the policy so that if something happened to you, then the money could be preserved for the child's milestones in life, such as college or graduate school, a wedding, or purchasing a home. But whether you're a single parent or a surviving parent, that young adult would have lost not only one of the closest persons in their life, but also the person who was raising and teaching them how to manage assets. It can be plausible that the young adult could quickly go down a rabbit hole trying to suppress some of that sadness and grief by either paying for large expenses such as a brand new luxury car or getting into drinking or drugs, or maybe they feel guilty receiving the funds and they decide to donate it to your favorite charity or give it out to their friends. The funds could be depleted pretty quickly. If your child has special needs, whether a minor or adult, any assets payable to their individual name could disqualify him or her from receiving those much-needed governmental benefits. It's really important to consider the stage of life your child is in and whether or not you should name him or her on your beneficiary designations. If there is a minor, an adult not ready to handle a large sum of money, or an individual with special needs, then I suggest creating a trust and naming that trust as the beneficiary of accounts instead. And in order to ensure you're taking the proper steps and using the correct language, you should work with an estate planning attorney. All right, that's it for today. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.